Hello, welcome once again to Leto's Law. I'm Steve Leto. A gentleman named John, who's a law student, sent an article to me that he thought I'd find interesting, and I did, and I think you'll find it interesting as well. I've talked before about how around the country these standards for being a judge change, and in the old days, anybody could be a judge. And then more recently, they said, well, you've got to actually have some legal training and so on, and probably be a member of a bar somewhere would be nice. But I'm talking about the judges who actually do the trial work in your community, the district court judges and the circuit court judges and the state courts and so on. But obviously, people have pointed out that to be a Supreme Court justice, there's no actual requirement that you have a law degree. You just have to jump through some other hoops. And the law degree will probably help you there. But this idea of this amateur judge sitting on the bench, many people go, well, it sounds appealing. The idea that you just have an average person sitting there and just the person just kind of uses common sense and just applies common sense. And guy comes in and says, hey, my neighbor ran over my pig with his car. I think he should pay for it. And the other guy goes, hey, dude, the guy's pig was running loose in my yard and I hit it in my own driveway. And the other guy goes, yeah, but he told me he hated the pig. He's going to kill it someday. And the guy goes, yeah, I hit it at night. I didn't know. So the question then is, can this common man or common woman judge pick a winner in a way that's as fair as a judge with a law degree? And most people go, what's a law degree got to do with that? Well, it's not so much deciding what's fair or what's right in a typical argument like that. It's procedural stuff that people think, the courts are too complicated. Well, they're often complicated to protect you. It might not seem like it, but the more complicated something is, sometimes it's good. Okay, I'd rather have a complicated watch than a non-complicated watch. But that might just be me. But some things. So the legal system, it all depends. But here we're talking about, and this article is old. This article is from 2006, but it's a great example of a story out of Duane, New York, and it's a great example of the idea of what happens when you have a judge with no legal training deciding cases that have, a legal effect. And in Duane, New York, a story happened where the judge's name is William Gorey, and he's the justice in a village of Duane, New York. So Gary Betters is the man who starts the story off, and he is a school psychologist. And he thought that the nearby village of Malone owed him $1,588. So he brought a small claims court case in Duane Town Court, where he winds up in front of Justice William Gorey. And so, like many others who go to court across New York State, he discovered that small town justice can be unusual. No one showed up to defend the village, and Justice William Gorey started the trial anyway. Betters, who was the plaintiff, testified at length, but he said that he was never even sworn to tell the truth. And then Gorey told Betters, well, give me a week and I will go ahead and decide the case. And he says he then almost immediately got a letter saying he'd lost. His case was dismissed and he lost. So he said, no reason was given. I cannot understand how a defendant can win when they don't even show up. And in most cases, if the other side doesn't show up, you do win. You win by default. So the State Commission on Judicial Conduct did an investigation. They figured it out. Justice Gorey went to the village offices in Malone before the trial, interviewed a witness from the village, and then he told them, don't even bother showing up, you guys win. Gorey, when asked, told the commission that he had never heard of the legal rule that a judge shouldn't talk to a party without disclosing it to the other side. In other words, Betters, the plaintiff, should have at least been told by the judge, by the way, I've already spoken to the other side. He also should have said, I already know him in a rule too. I mean, why not? If you've made up your mind before the trial starts, why pretend you're letting the guy put in his case? He then tried to defend himself by saying that he'd read a manual on how to be a judge, and it's not even explained in my manual. And so this lack of knowledge on legal concepts is apparently common in what are known as the justice courts, which of course are left over from the colonial era. And at that point that the article was written a little over 10 years ago, there were still 1,000 of these around New York apparently. And things that hang on from the colonial era Recipes, maybe. The legal system, it should be updated. For generations, justices have hailed them as poor man's courts, where ordinary people can get simple justice with little formality or expense. But the same is true of small claims court. There are few more vivid spots to view their shortcomings than here in one of New York's poorest corners, Franklin County, a place of rugged beauty on the Canadian border where only one of the 32 local justices is actually a lawyer. This, by the way, is by William Glaberson out of the New York Times. And he says, the county's justices have repeatedly drawn the attention of state judicial conduct officials, with 15 of them publicly disciplined since the 1970s. Some of them have been disciplined more than once. Justice Gorey's errors pale in comparison with those of some others. One justice freed a rape suspect on bail as a favor to a friend. Another sentenced a welfare recipient to 89 days in jail after she failed to pay a $1.50 cab fare. Franklin County justices have presided drunk, fixed cases, and by fixed we mean rigged them, and denied lawyers to defendants. One failed to appoint a lawyer for a 19-year-old mentally retarded alcoholic defendant. Why would he deserve an attorney? So in Duane, Justice Gorey is in many ways a typical small-town New York justice. He was a bricklayer and a former dog trainer. He does have a high school education. He's 59 years old at the time the story is written. And on Thursdays, he goes down to the firehouse where he holds court. And he admits that his temper sometimes gets the better of him. He doesn't have a judge's bench, very few law books, no law clerk, and he says that basically he's doing the job because nobody else wanted it. He seems well-intentioned, as the author points out. Like many justices, he describes his job as a public service. But the problem is that when the Judicial Conduct Commission called him to account for his handling of Mr. Better's case, his defense was startling. A transcript of the hearing shows his own lawyer blamed the state for running the justice courts as it does. Judges with so little training could not possibly know the basic rules for handling a lawsuit. Therefore, it's not their fault. It's the state's fault. And by the way, I agree with that. If somebody hires an incompetent person and goes, hey, look, you're incompetent. Well, you shouldn't have hired him. And you say, well, no one else wanted the job. Maybe no one wanted the job because it's thankless, doesn't pay enough, or there's something else wrong with the system. Okay? But if you told me, Steve, in your community, they need someone to come in one day a week, or one night a week, apparently. It's like night court. One night a week and just hear disputes and make rulings. I would do it. I'd gladly do it. We just don't have those kind of wacky courts in Michigan. The county's district attorney says that when he took office 5 years previous, he had to drop hundreds of criminal cases because justices had failed to take any action for so long. He says his staff of 4 full-time prosecutors is too small even to regularly visit the courts, which are separated by great distances. And Franklin County is bigger than Rhode Island, so it has only one higher court judge in the county court in Malone. So the part-time town and village justices, who are plumbers and meat cutters and school bus drivers, are often the last word on the law, with the power to issue search warrants, conduct trials, jail people, or let their friends go free. The reality is, and this is a quote from the prosecutor, you basically have to have no qualifications other than be a voter to put someone in jail, and that is very alarming. To put a lay person, some of whom don't even have a high school diploma, in that position is just a recipe for disaster. So they spent a day watching Justice Gorey operate at his job here, and they pointed out that he does have a computer, a court computer, but it was paid for with his own money, so he keeps it at home. He doesn't wear a robe on the bench because they're too expensive. And he says that for the job he's paid $3,700 a year, $3,750 a year. So it's probably thankless. And then when asked, he said there are certain things that are lacking. You know, speaking the obvious. By the way, the town of Duane has a population of 159. And he said that he moved there, the judge did, because he wanted a chance to be able to hunt with his dogs, and apparently there's a good hunt in there, so that's good. Justice Gorey also said he likes the solitude. And by the way, he's gotten remarried since moving to town. And he says that when you get up here at night, when the highway quiets down, you don't hear anything, which of course is an attractive thing to have in a neighborhood. So That's the situation with some of these small courts in some parts of the country. And some places have moved to reform these, but they still exist in other places. And, the thing about it is, like, if you watch People's Court or Small Claims Court in your town, there's jurisdictional limits. You can only sue for so much. But in Michigan, for instance, they're overseen by either a judge or a magistrate who has legal training, and they use rules to make sure the court goes smoothly. And now you might say, Steve, earlier you mentioned something about whether or not the judges can just use common sense to run a courtroom. And on some levels, you'd say, it makes sense to me that, like I said, with the example of the neighbor who ran over the pig, isn't that something that just, you got one adult there, one adult here, and I'm the adult in the middle, and can't we work this out, or I'll come to a decision? And you say that seems to make a lot of sense. Where it falls apart is procedurally, the rules of evidence, for instance. So two people come into court and they want to have a fight over some money. So one side wants to put in inadmissible evidence, and the other side immediately spots there's something unfair about it. And the judge, who has no legal training, goes, "Oh, what do you want? What do you want to say now?" And they want to say, "Oh, by the way, my neighbor here is a convicted felon." And the judge goes, "Really? You're a convicted felon? I'm going to rule for this guy here because he's not a convicted felon." What was the felony? How long ago? And is that admissible? Because in many cases it's not. And so I'm not going to get into a dissertation on evidence here, but the point is that there's a reason that there's a rule on that. There's a reason why the judge should know that. And so the idea, for instance, that one party comes into court and makes a case. Now you might say, Steve, that person doesn't always win, do they? And no, there are cases where someone could come into court unopposed and still lose. And I'll give you an example. Let's suppose someone came into court, raised their hand. I had them sworn to tell the truth. They go, "Why are you here?" And they go, "My next door neighbor is controlling my thoughts." And I say, "Okay, how are they doing that?" "They're doing it through the microwave oven." How does that work? They go to their microwave oven and they type instructions into it. And when they hit go, it causes my thoughts to get scrambled. And it makes me want to do things like drink alcohol and take drugs. And it all started when they moved in next door and got a microwave oven. I want you to give me $10 billion. Now, the other side's not there. We could issue a default judgment for $10 billion, except for my court probably has limited jurisdiction, and it does. So let's say the cap on my jurisdiction is $5,000. Do I give them $5,000 because they think their next door neighbor is controlling the thought waves of the microwave oven? No. And what they're doing there is, depends on how you want to look at it, but there's two kinds of lawsuits that can be thrown out on their own, and one is where you fail to state a claim. I've mentioned this before, where you're suing somebody for something that's not illegal, or no genuine issue of material facts, where the facts could never be spun in a way to let you win. And anybody who knows how microwave ovens work or don't work, or how the human mind works, would go, "This person's crazy. They're crazy." Okay. And what you do instead is you say, "I'm really sorry, but I'm dismissing your claim right now. I would suggest you wrap your head in tinfoil and go home and take some aspirin." Now, on the other hand, if someone comes into court and goes, "My next door neighbor ran over my pig. I served him. He's been served with the papers. I actually, before that, tried to settle it with him, and he said, 'I don't care.'" Now, you might say, "Steve, that guy might have a good defense to that." Yeah, and if he's been notified of the hearing, he should come to court and defend it. If he fails to come to court and defend it, and the person standing here sounds like they've got a good case, I can rule in their favor. And I would do that all day long. Now, the other person might come to court later and say, "Hey, I didn't get no order." And if there's a reason they didn't show up, we might set it aside. But the point is that when you rule against the unopposed party because you've already made up your mind by interviewing the defendant, and you've already ruled, in essence, in your head against the person before they presented their case, that's not just misunderstanding the procedure of a courtroom. That's actually doing it wrong. That's a person who doesn't even understand the most fundamental concepts of how this works. Everyone should know that the judge should be impartial, and all that matters should be what happens in the courtroom. Okay? One person comes in and states their case. Another person comes in and states their case. The judge hasn't got to deal with one side, hasn't got to deal with the other side. The judge isn't going to go out and talk to other people who aren't here. The judge is going to go, "Do you have witnesses? Do you have witnesses?" hear the case that's within these four walls and make a ruling. That's how it's supposed to work. So could that happen with somebody who's not an attorney? It's possible, but it becomes highly unlikely. But when you hear the abuses, you realize it's a problem. Should these people who are not trained be allowed to sign warrants? Okay? If they don't understand the law, how are they doing that right? Okay? So that's an even bigger problem. So that's the issue with the unqualified judges from the great story from a few years back in New York. I hope they're working on fixing this, and I'll double check on that, but the story itself was fascinating, so I read it, and I hope you enjoyed it too. Questions or comments, put them below this. Talk to you later. Bye-bye.